Okay, so this one is called Legislative Courts versus Common Law Courts. We're going to do a little comparison. And by the way, they're all legislative courts, all the ones out there. There's only one court that's not legislative, and that's the Supreme Court of the United States. Anyways, first of all, I'm not a liar. Well, I'm in a lawyer. No, I'm in a liar. You should never take my word for anything. You should always do your own research. I provided references to aid you in your research, but I don't know everything, and I'm open to any ideas. And oh, by the way, this PowerPoint presentation will be available in the show notes below the video for any of you that want the sites and all that stuff. There's 4 types of people you'll meet in your life. There's the people who try to wake up the slaves. There's the slave masters. There's the people who have no idea they're slaves. And there's the people who like being slaves. Which one are you? Do you really know for sure? Are you who you think you are? If you can see through the illusion, then you are the solution. If the people don't know their basic rights and freedoms, how can they know when or if their rights and freedoms are being infringed? Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot the cops. Think about it. This is obviously a painting right here, but these kinds of scenes did take place, and they did get up in the middle of the night and go and engage the British. Think about it. That's exactly what they did. That's a militia right there that's getting ready to go out. Talk about balls. We, the people, need to convene our own militias. That's another video. There's other videos that I've got that already talk about that. All tyranny needs to gain a foothold is for people of good conscience to remain silent. I don't trust the government. I don't trust the medical, pharmaceutical, industrial complex. I don't trust the military industrial complex. I don't trust the mainstream media. I don't trust the bankster criminal cabal that owns the government, owns the medical, pharmaceutical, industrial complex, owns the military industrial complex, and owns the mainstream media. And if you call me a conspiracy theorist, I don't trust you. Government's not reason, it's not eloquence, it is force. Like fire, it's a dangerous servant and a fearful master. So what we have here is American Jurisprudence, 2nd edition, Book 20, Section 103, and Book 21, Section 2. Top part is Book 21. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Well, so think about it. They're always administrative, okay? They don't do common law. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treating as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within its scope of its jurisdiction does not apply. It is familiar law that when statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc, a court of inferior or limited jurisdiction. And so there we go, right there, is that when they're operating under a statute in derogation of common law, they're always operating under a statute in derogation of common law. I haven't seen one yet that wasn't. The only time, like maybe a petition for writ of mandamus with the Court of Appeals, so I guess there's some times when they do that, if they do it strictly common law. But in the lower courts, you'll never, ever see justice at the hands of these Baal priest Satanists in the lower courts. You'll never see justice. And so what you have to do is build a case against them and prepare for the Court of Appeals and the mandamus. File challenge jurisdiction, automatically challenge jurisdiction every time. And some courts you can do a preemptory challenge. Preemptory challenge means that you can do an interlocutory challenge, okay, which means before the final judgment. Some courts you have to file a motion to proceed interlocutory before the final judgment. If they deny your challenge to jurisdiction, all you need is that order, okay? And some courts, like I'm working on one here in New Jersey right now. I'm in New Jersey. And so in New Jersey, you cannot file just because the judge denied your challenge to jurisdiction. They're not going to, you can't file with the Court of Appeals. You got to go to the Supreme Court or the appellate division of the Superior Court. Anyways, in New Jersey. Anyways, what you have to do is you got to file a motion. You got to let them deny it, and then you got to file a motion, and maybe they'll do it, maybe they won't. It is a ministerial duty is one which is required by statute. A ministerial act is an act of a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority without regard to his own judgment or opinion concerning such act's propriety or impropriety when a given state of facts exists. Discretion, on the other hand, is the power conferred on public functionaries to act officially according to the dictates of their own judgment. So, again, they're acting ministerially. They're acting administratively, okay? And they always do that. The word administrative is synonymous with the word executive. The word administrative connotes of or pertains to administration, especially management, as by managing, conducting, superintending the execution, application, or conduct of persons or things. Thus, administrative acts are those acts which are necessary to be done to carry out legislative policies or purposes already declared by the legislative body. In fact, it is common to use the two words in tandem. A court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. And so they're all, well, a lot of them are general jurisdiction. The district courts, like in New Jersey, is called the Superior Court. They're all general jurisdiction, but they never operate. They're never operate under common law. Okay, they're always administrative somehow. The penal code, okay, that's a contract. That's commercial. It's always so they're always an inferior court of limited jurisdiction. It is noted as significant that the act constituting a court dispenses with trial by jury, a provision which is distinctly upheld in spite of the Seventh Amendment. With respect to the status of the court, the opinion concludes a duty to give decisions which are advisory only and so without force as judicial judgments may be laid on a legislative court, but not on a constitutional court established under Article 3. There's no Article 3 courts. Okay, the only Article 3 court is the Supreme Court, and that's it. And also common law courts, we the people. Okay, they can be Article 3 courts too. Where controversies of such a character as to require the exercise of judicial power defined by Article 3 jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal or, of course, in an executive officer or administrative or executive board, since they are incapable of receiving it. International law rule. adopted for areas under federal legislative jurisdiction. Remember, we're talking about legislative jurisdiction, legislative courts. Federalizes state civil law, including common law. The rule serves to federalize not only statutory, but the common law of a state and federal venue discussed. The civil laws effective in an area of exclusive federal jurisdiction are federal laws, notwithstanding their derivations from state laws. And a cause arising under such laws may be brought in or removed to federal district court under sections 24 or 28 of the former judicial code, now sections 1331 and 1441 of Title 28 United States Code, giving jurisdiction to such courts in civil actions arising under the laws of the United States. And that's taken from Jurisdiction over Federal Areas Within the States, report of the Interdepartmental Committee for the Study of Jurisdiction over Federal Areas Within the States, Part 2, a text of the law of legislative jurisdiction submitted to the Attorney General and transmitted to the President June 1957, page, and it's basically extracts from pages 158 to 165. So the point being is that these legislative courts are inferior courts of limited jurisdiction. That means all municipal courts, all divorce courts, all federal courts except the Supreme Court under some circumstances. Okay, the Supreme Court, there is a Supreme Court of the District of Columbia. Okay, that's a legislative court. Okay, and there's also a Supreme Court of the United States. And what they did to be deceptive, because they don't want you figuring out that's what's going on, they just call it all Supreme Court of the United States. Okay, the District of Columbia is called United States. And so they do that on purpose so they can deceive you. They want to be deceptive so you don't know what's going on. And so unless you know the arguments, it's all based on what's being presented. All state courts created by statute, all of them are, like, for example, judiciary courts of the state of Texas. Okay, that's all of the courts in Texas, and it's created by statute. It's a corporation. Here it is right here. Let's get in a little bit closer. It says, this is a Dun & Bradstreet report. Business background report for the judiciary courts of the state of Texas. This was printed in January 29, 2008. Dun & Bradstreet business background report. Judiciary Court of Texas, State of Austin. This stuff is kind of hard to read. It's kind of fuzzy, but year started 1845. P.O. Box 12248, Austin, Texas. Supreme Court Building, Austin, Texas. They even give you a telephone number. Top executive, Chief Justice at the time. Line of business, state court system. So this is all taken from a Dun & Bradstreet report. So they're all legislative courts. Think about it, folks. This goes on the same page. Business started in 1845 by the citizens. Thomas A. Phillips, Chief Justice of the Supreme Court of Texas since 1986. 96? I think it's 96. So 12204, subsidiary of Texas, State of Austin, Texas, started 1845, which operates as a state government. Intercompany relations, none reported by management. As noted, this company is a subsidiary of Texas State of Inc. And references made to that report for background information on the parent company and its management. Anyways, it's a corporation. So my opinion is, and long has been, that the mayor and aldermen of a city corporation or the president directors of a bank or the president directors of a railroad company or other similar corporations are the true parties that sue or are sued as trustees and representatives of the constantly changing stockholders A corporation, therefore, being not a natural person, but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or of the United States, and cannot fall within the terms or the power of the above-mentioned article, and that can therefore neither plead nor be impleaded in the courts of the United States. So again, it comes down to standing, okay? No corporation is standing to say anything to any man or woman. Tyranny, this is John Locke, okay? 2 Treatises of Government, Book 2. Tyranny is the exercise of power beyond right, which nobody can have a right to. And this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the governor, however entitled, makes not the law but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. That's tyranny, folks. This is what the Founding Fathers were reading. 'Tis a mistake. Okay, so that's section 199. Now we're going to read section 201. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it, as well as that. For wherever the power that is put in any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. This is what the Founding Fathers were reading. And that means that these courts are tyrants. Okay, that's exactly what they are. They're tyrants. There's tyranny going on all over the place, folks. It's time to wake up. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial. Well, gee, that sounds like a legislative court. And for altering fundamentally the form of government established by charter, we saw the misery to which such despotism, that's dictatorship, folks, would reduce us. And that's cause the necessities for taking up arms 1775. So think about it. That video, that shot that I showed of the militia getting ready to go, and they say that 3 to 5% of the people were responsible for the War of Independence. But, you know, in those days, and if you watch that video that I did on militias, it says that in those days, it's based on a book that was written by Edwin Vieira, who's a pretty smart guy. But he goes through and shows all of the original statutes that were passed in colonial days, because the Constitution has to be looked at in light of the times that it was written in. And so they were required to be armed. Everybody was required to be armed. If you were going to a public meeting and you weren't armed, you get a fine. Okay, if you went to if you were out of town more than 2 miles and you weren't armed, you get a fine. So everybody was required to be armed. You had to be armed at all times. And so that was, and it was 3 to 5% of those people that caused the War of Independence. And so the governors were all appointed by the British. So they weren't in favor of the War of Independence. So it was basically the people. And they had the arms, and they went and, you know, like I said, they were going out and engaging the British. Talk about balls. But they were organized and they knew what to do. The United States District Court is not a true United States court established under Article 3 to administer the judicial power of the United States, but was created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of making all needful rules and regulations respecting the territory belong to the United States. Okay, so again, it's a territorial court. And actually, you know, they're all in, it was zip codes, so they're all District of Columbia. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steam at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steam, don't forget to vote and make your comments. And BitChute, there's my BitChute channel. That's the front page of my YouTube channel. The subscribe button's already been clicked because otherwise it'd be red. The bell has not been clicked because it's not vibrating, so there was no notification. So the arrows point at the bell. Click the bell so you get notified. Bad behavior. The judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during the continuance in office. That's the Constitution, Article 3, Section 1. So the point being is they only hold office during good behavior, okay? And when they're in bad behavior, they're not a judge, okay? And we'll talk about that some more. It's going to be coming up. Fraud upon the court is fraud which is directed to the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted or influenced or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted. That's fraud upon the court, okay? If they're working for the executive branch, then there's fraud upon the court going on. An officer who acts in violation of the Constitution ceases to represent the government. Officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. Where any state proceeds against a private individual in a judicial forum, it's well settled that the state, county, municipality, etc., waives any immunity to counters, cross-claims, complaints by direct or collateral means regarding the matters involved. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. Sue their fucking ass off. Immunity for judges does not extend to acts which are clearly outside their jurisdiction. You got to sue them in their private capacity, okay? They have immunity in their official capacity. You can pierce right through that immunity just by showing that they're in bad behavior and they're in private capacity. And you sue them in their private capacity only. I'd like to see them living in a cardboard box on the street. In arriving at our decision in this matter, we do not depart from any way from our holding in Hundling versus Jensen that the doctrine of judicial immunity extends to courts of limited jurisdiction, but when a minor magistrate acts wholly without jurisdiction, civil liability attaches for his malicious and corrupt abuse of process and his willful and malicious oppression of any person under the pretense of acting in his official capacity. So what they do is they're working for the executive branch. Think about it, folks. And they send out their screen for low intelligence hired thugs to assault you to bring in business for their so-called court. And you are the enemy. Think about it, folks. That's what's going on. You are the enemy. Murdered by the police. This is, I think, in Chicago. And what's that? 3, 2, 4, 6, 8, 10, 30 people. The police murder people all the time. We talked it over, and after investigating it ourselves, we decided we're not guilty. You are the enemy, folks. Time to wake up. Beware violent street gangs. There's a gang member right there. Typical gang member. Gang colors, heavily armed, well organized, gang identifier. Do not approach gang members, are aggressive and notoriously violent. Can you spot the terrorists? Terrorism is a noun, use of violence and intimidation for the pursuit of political aims. Help! Help! A violent psychopath is trying to kill me. Please direct him to our website to download a job application. He'll fit right in with our group. Has he got low intelligence? We want a hired thug. Warning, this is the standing army you are told not to tolerate. Order followers are the ones who keep the system of slavery in place. And that's Mark Passio, A pretty brilliant guy, former Satanist priest. And he's got a YouTube channel called What on Earth? What on earth is happening? Officers in Rialto, California are now required to wear video cameras while on duty. In 1 year, use of force dropped 60% and complaints have dropped by 88%. Gee, why is that a surprise? Have you had enough of the order followers, or do you need to be abused some more? Order followers are the servants of evil. You assist an evil system most effectively by obeying its orders and decrees. An evil system never deserves such allegiance. Allegiance to it means partaking of the evil. A good person will resist an evil system with his or her whole soul. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo.com. My YouTube profile is Sovereign Living. My Facebook community page, I deleted it a long time ago due to censorship on the part of Facebook. My private group on Facebook, I haven't been to Facebook on months, if not years. I am not even remotely interested in going there. They're just, if I really, what I need to do is go on there and ban everybody off that group. If I went and just by not being there, Facebook gets the profit. They make money off of that group. And what I need to do is ban everybody off of that group and then delete the group. And that would do it. But yeah. Anyways, don't get me going. Freelist.org has a group called Sovereignty International. My Google group, or not Sovereignty International, Administering Your Public Servants. My Google private group is Administering Your Public Servants. Follow me on Steemit at Sovereignty International, BitChute, Sovereignty International, and I have some subscription videos, some exclusive videos on how to at Sovereignty International. Order followers are bringing in business for their fake courts that are actually part of the executive branch. A mixed war is one made on one side by a public authority and by the other with mere private persons. Order followers are working for the executive and they're bringing in business for their fake courts. Under international law of warfare, all parties to a cause must appear by nom de guerre because an alien enemy cannot maintain an action during the war in his own name. When acting to enforce the statute and in subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely acts as an extension, as an agent for the involved agency, and only in a ministerial, not a discretionary capacity. Judge works for the state, prosecutor works for the state, police works for the state. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party, and since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. It's exactly what's going on, folks. Time to wake up. It's the accepted rule not only in the state courts but in the federal courts as well that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes. As a ministerial clerk for the agency, a bought and paid for clerk. And administrative is executive. Okay, that's the executive branch. Law enforcement officers enforce statutes. Law enforcement officers are not peace officers. Law enforcement officers are operating in their private capacity. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities, okay? It's all a nullity. They don't have a shred of authority. They're not competent to issue orders or judgments. Things that you see every day using the satanic philosophy of moral relativism. False flag operations, the end justifies the means. Agent provocateurs, the end justifies the means. Entrapment, the end justifies the means. This is all stuff that goes on every day. All court cases are kangaroo court because unless it's a common law court, it's satanic. The judges are bought and paid for a clerk playing stupid and working for the prosecutor. If you don't know the law or fail to do something properly or follow the right procedure, they sell you into slavery. They have no authority whatsoever. They can't make judgments or rulings, and they use this uniform commercial code. They're nothing but a bunch of thieves and pirates. Judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. The judges of both the Supreme and inferior courts shall hold offices during good behavior. So they're in bad behavior, and they're not judges. And you just pierce right through their immunity and sue their fucking ass off. I have exclusive content available on howto.com. It's $9.99 a month for the videos plus unlimited email consultations, but I'm not a liar. Well, I'm an attorney. Well, no, I'm not a liar. But I can tell you what I would do under certain circumstances and where to find the forms. The only power that these New World Order Satanists have over us is through fraud and just deception, and my agenda is to expose it for all our benefit. I cannot fight all the battles. I need other people being on point. Some of the website content, the exclusive, this is on How To, but it's also on my website right now. Arlington Private Information Share, Land Deed Training, Estoppel Certificates Training, Foreclosure Estoppel Certificates Training, for corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation signature training, third-party witness training, federal habeas corpus training, revocation of voter registration, criminal complaint training. I've got about 3 videos up on that, and I need to put some more. Lawsuit training, I got 1 video on that. I need to put some more. Other training requests, I'm open to requests, but it has to be something that I haven't already done, and something that I can do. Northeast Private Information Share videos are up there. All forms, files, and other instructions are available for free, linked on my videos and on my website. All exclusive content will be on HowTube, and you can buy a subscription there. HowTube handles all of the billing and everything. It works pretty good. I don't have to worry about it. I'd like to take cryptocurrencies. You can send me donations by cryptocurrencies. On my website, I could take cryptos, but that's coming to an end. Okay, this is Downs versus Bidwell, U.S. Supreme Court, 1901. Eliminating then from the opinions of this court all expressions unnecessary to the disposition of the particular case, and gleaning therefrom the exact point decided in each of the following propositions may be considered as established. Number 1, that the District of Columbia and Territories are not states within the judicial clause of the Constitution, given jurisdiction in cases between citizens of different states. That the District of Columbia and Territories are states, as that word is used in treaties with foreign powers with respect to the ownership, disposition, and inheritance of property. That the territories are not within the clause of the Constitution providing for the creation of a Supreme Court and such inferior courts as Congress may see fit to establish. So what happened after this is they started coming out with certiorieries for the Supreme Court. Number 1, and as you know now, it used to be the writ of error. It used to be you could go to the Supreme Court with a writ of error, but I still think you can. The problem is that the Supreme Court of the United States doesn't deal with anything to do with territories or the District of Columbia. You got to understand that. And so if you bring an action through the federal courts, you're in a territory. So you have to bring it from a state court directly to the Supreme Court. And there's actually a case that I saw that in the 60s. There was a case, Texas, Brown versus Texas. I think it was Brown versus Texas or Texas versus Brown. Anyways, it was an El Paso County Court at Law case. It was an appeal. And it doesn't say that it was a writ of error, but I think it was because they appealed directly from the county court at law in El Paso County, Texas. And the Supreme Court answered it. And so the important thing to keep in mind is that, in the rules and stuff like that, the rules are kind of vague and they don't really tell you all the things that you can do. Anyways, for what that's worth. So you can't, someone who's a state national can't sue a U.S. citizen as being a foreigner. Okay, you can't do that because, number one, the District of Columbia and the territories are not states within the judicial clause giving jurisdiction in cases between citizens of different states. So even though they're foreigners, U.S. citizens in your state, you can't do that. They won't let you do that. But you can sue them. There's other ways if you want to take it in the federal courts. Anyways, what happened also after that is they came out with a rule called Cestacate Trust, because here they're talking about inheritance of property. Okay? District of Columbia and the territories are states, as that word is used in treaties with foreign powers with respect to ownership, disposition, and inheritance of property. That's when they come out with a Roman called Cestacate Trust in the D.C. Code, the Code of Law for the District of Columbia. So there's a bunch of things that came out after this case. Matter of fact, Congress passed, I think that they went and approached, the Supreme Court told the Justice Department what they were going to do. And so then Congress passed the D.C. Code. I think they argued this thing in like January, and then in March they come out with the D.C. Code, and then in June they come out with a ruling. So they wanted to come out with a D.C. Code before then. So this is in the D.C. Code. And said Supreme Court shall divide said district into 10 subdistricts. That's where zip codes come from, folks. Where the justice thereof shall have office for the transaction of business, may change the boundaries of such subdistricts and locations of offices of the justice therein from time to time, as volume and convenience of the business may require. That's how they went, and that's zip codes. All corporations are in a zip code. There's a major part of the Code of Law for the District of Columbia. It's all about corporations. And all government offices are in this code. The United States Postal Service is a corporation domiciled in the District of Columbia. Every corporation, for all its purposes, is an agency of the bitch. Well, I guess it's now the son of a bitch. That's in the Canada Government Corporation Operation Act of Canada. And then in this act, owned means subject to the regulations. So if you're subject to the regulations, you're owned. The Congress shall have power to dispose of and make all needful rules and regulations respecting the other property belonging to the United States. And so it's the same in the U.S. Your other property of the United States, if you're subject to the regulations, you're owned. Should a suit be brought against any party or corporation in any district in which he or it does not reside or hold business, and a plea to the jurisdiction on this account be filed by said defendant, the party or corporation interposing such plea shall disclose under oath the district in which he or it should have been sued. And so that's Code of Law for the District of Columbia. That's found in Section 31 Stat 1280. There's a whole big section on corporations. And it all falls under the Commerce Clause, Article 1, Section 8, Clause 3. So all these corporations are dragging you into the Commerce Clause is what they're doing. We therefore decline to overrule the opinion of Chief Justice Marshall. We hold the District of Columbia is not a state within Article 3. This is 1948. Within Article 3 of the Constitution, in other words, cases between citizens of the district and those of the states are not included in the catalog of controversies over which Congress can give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So if you're a corporation, then The boundaries of the District of Columbia expand as necessary. And they're assaulting you with their Commerce Clause is what they're doing. Matter of fact, I don't know how many of you remember the Kavanaugh hearings. When Kavanaugh was appointed to the Supreme Court, this was during the Trump administration. He appointed Kavanaugh, or he nominated Kavanaugh, had to be approved by the Senate. Anyways, Kavanaugh, they asked him, can we go after a U.S. citizen in Afghanistan? And Kavanaugh said, yes, we can. Because the boundaries of the District of Columbia expand as necessary. More than out the states of the Union anywhere. Democracy. Fake laws, false arrest, feel free. Democracy is dictatorship. In doing this, I shall have occasion, incidentally, to evince how true it is that states and governments were made for man, and at the same time how true it is that his creatures and servants have first deceived, next vilified, and at last oppressed their master and maker. A state like a merchant makes a contract, a dishonest state like a dishonest merchant willfully refuses to discharge it. Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who lit their beds at night to shoot at the cops. And the governors were all appointed by the Crown. And they were all required to be armed. And those 3 to 5% that actually caused the War of Independence. So that's what they were doing, is they were going out and engaging the British. They knew what to do. We need to start up our own militias, folks. War is when your government tells you who the enemy is. Revolution is when you figure it out for yourself. In that video I did about militias, Edwin Vieira postulates that a Republican form of government requires a militia. And he even said in that book, he said that if we failed to reconstitute our militias, that we would wind up with a police state. And that's exactly what we have right now. So it's time, folks, time to wake up. When liberty and freedom are at stake, your silent isn't golden, it's yellow. So we'll talk about common law courts now. Judicial power is the power to hear those matters which affect life, liberty, or property of citizens of the state. The very meaning of sovereignty is that the decree of the sovereign makes the law. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. The sovereign is exempt from suit not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects and have none to govern but themselves. The citizens of America are equal as fellow citizens, joint tenants in the sovereignty. And brings into action and enforces this great and glorious principle that the people are sovereign of this country, and consequently that fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined. And that doesn't stop these sons of bitches at all. Judges cannot make law. Judges can only compare a given case and other similar cases and make a ruling based on what other courts have done. It's called stare decisis. If there's a case that has not been previously decided, then they have to convene a jury. And the U.S. Supreme Court did exactly that in like 1802 under Justice Marshall. They convened a jury because they said, you need to tell us the law on this matter. There was something that had not been previously decided. Stare decisis, the doctrine of precedent under which it is necessary for a court to follow earlier judicial decisions when the same point arise again in litigation. The rule of adherence to judicial precedents finds its expression in the doctrine of stare decisis. Some people call it stare decisis. This doctrine is simply that when a point or principle of law has been officially decided or settled by a ruling of a competent court in a case in which it is directly and necessarily involved, it will no longer be considered as open to examination. U.S. attorneys must recognize that the grand jury, so we're going to talk about grand juries too. U.S. attorneys must recognize that the grand jury is an independent body whose functions include not only the investigation of crime and the initiation of criminal prosecution, but also the protection of the citizenry from unfounded criminal charges. And that's the U.S. Attorney's Manual. The manual recognizes that targets of investigation have the right and can request or demand the opportunity to tell a grand jury their side of the story. The Supreme Court states that the independent grand jury's purpose is not only to investigate possible criminal conduct, but to act as a protector of citizens against arbitrary and oppressive government action, and to perform its functions, the independent grand jury deliberates in secret and may determine alone the course of its inquiry. An independent grand jury is to stand between the prosecutor and the accused and to determine whether a charge is legitimate or is dictated by malice or personal ill will. The grand jury is to protect citizens against hasty militia and oppressive persecution and to ensure that prosecutions are not dictated by an intimidating power, by malice and personal ill will. The independent grand jury is described as a body with powers of investigation and inquisition. The scope of those inquiries is not to be limited narrowly by questions of propriety or forecasts of a probable result of an investigation. You know, I don't know if anybody's seen that movie about the runaway jury. That was a runaway grand jury is what that was. You know, to watch it, it's pretty interesting because that's what grand juries should be doing. Really, I'm serious. They need to, a lot of times these prosecutors try and steer the grand jury down a certain path. And the grand jury needs to start investigating and they just say, bring this guy, we want to talk to him or something like that. You see what I'm saying? And they need to just take the ball and run with it and not let the prosecutor tell them what to do. My new Trump book is not available. Trump, a true American patriot or not? Mike Blackwell asked me to write the book, and it took me about six weeks to write it because all I did is I took a lawsuit and manipulated it and turned it into the book. And so, and the people that he hired some people to help us with it, and they actually wrote the stuff on the back of the book. And so I think they kind of nail it here. It says, in Trump, a true American patriot or not, Glenn Fern and Mike Blackwell reveal the depths of corruption, deceit, and manipulation infesting our political system for hundreds of years, regardless of political affiliation. Read the hard evidence that exposes how our elected officials sold Americans into slavery, understand the Founding Fathers' true intent when they formed our Republican form of government, discover the influence of the satanic Roman cult in our Republican, on our politicians and political system. Does Donald Trump want to transfer power back to we the people? In Trump, you will see the great battle that is upon us. And I think they nailed that really well. You can order the book from Amazon.com or from my website. It's $40 plus shipping. I prefer you order from my website, sovereigntyinternational.fyi. Amazon does not provide autographed books. If you want an autographed book, then you got to order from my website. You want to know the origins of the deep state? Who's behind it? It's in the book. You want to know why it's called a Trump administration? You want to know what an administration is? Do you want to know how Trump came to be president? You know, he was invited. Yep, there's in the book. There's a guy by the name of Jerome Corsi. Oh, I'll talk about that in a minute. Anyways, do you want to know who owns Congress? Do you want to know why they're called law enforcement officers? They're enforcing the martial law. And Congress is owned. Why do you think Pelosi would get up and say, we can't read this bill until after we've passed it? Taking orders from the owners. Do you want to know how you have become a slave? You want to know what the root cause of the War of Independence was? It's in the book. It's the same thing, exactly the same thing that's going on today. Do you want to know why every president goes to visit the pimp? Well, I meant the Pope. No, the pimp. On their first international trip, it's in the book. And I want to say right here now that I have nothing against people that are Catholic. Some of my best friends are Catholic. Matter of fact, there's a good friend of mine that he kept telling me about the corruption and stuff that the Pope was involved in, and I just refused to believe it for a long time until it just became so obvious. And so, so it's certainly not to say anything negative about people that are Catholic. There's lots of wonderful people that are Catholic, and they don't like it any more than the rest of us. Matter of fact, there's where was it I was seeing? There was something about, I was reading an article one time about a bunch of Irish fathers or bishops. I think there were bishops that were basically just a whole group of them were separating from the church. And then there was some in Argentina too. There was I think all of them in Argentina or Chile. Down in South America, there was a bunch of them down there too that basically didn't want to have anything. The Pope is a Jesuit. He's a Satanist, and most Catholics consider themselves Christians, and so that's the problem. I'll tell you right now. Anyways, Mike asked me to write the book, and it took me about 6 weeks to write the book, and then he had to babysit me through 6 months of getting it ready to publish. And so I put him on the book, but I wrote the book. And Jerome Corsi is. I don't know how many of you have heard of Jerome Corsi. He's a guy that lives up in the Northeast. He's written a bunch of books. He's got a PhD in political science from Harvard, and he's written a bunch of books. He's got a YouTube channel, a website. Anyways, he says there's a YouTube video where he says that in 2015, 5 generals came to see him, and they said they were going to overthrow Obama. And he said, well, you can do that if you want, but you might want to go talk to Donald Trump first. 3 months later, he gets a phone call. They decided not to overthrow Obama because Donald Trump had agreed to run for president. So he was invited for sure. Anyways, it's 95% provable facts because it's a lawsuit. I use court cases, law dictionary definitions, international treaties, all sorts of stuff to prove everything I say. But there is a little bit of opinion, okay? And some of the opinion is about Howard Hughes and the helicopter crash in 1984. Howard Hughes, I think all of these billionaires, this is my opinion, I think all of these billionaires get approached by the New World Order crowd and get told you're going to go along with our program, you're going to turn up dead. And matter of fact, Warren Buffett went to see Bill Gates one time, and all of a sudden he donated like a couple $2 billion to the Gates Foundation. Anyways, and now I'm hearing that Warren Buffett is having a falling out with Bill Gates, and Bill Gates been charged as a pedophile. So I'm glad. Yeah, it's too bad he had to give up a bill or two to do it. Anyways, who knows what kind of he might have had some strings on that. It's hard to say. Anyways, and then there's Howard Hughes. The reason he was hiding out all the time. When I wrote the book, I thought that he was hiding out because he had been approached. But I have since learned some other things. The matter of fact, there's a David Wilcock video where David Wilcock says that after World War II, Howard Hughes got blackballed. He couldn't get any defense contracts. And so he wanted to know why. And he got some young ladies to go and sleep with the military-industrial complex types and found out from Pillow Talk why they had blackballed Howard Hughes, because they were planning on doing what they're doing now. Howard Hughes was a true patriot, and they were planning on doing what they're doing right now. So anyways, they were planning on taking over the world, okay, creating a global plantation. And so according to David Wilcock, Howard Hughes had set up a bunch of books and manuals and procedures for them to on how to defeat it all. And Kennedy circulated $6 billion of the U.S. Treasury notes. And a week before they killed him, he came out and he said he was going to expose it all. And then, of course, we all know what happened in history. And so I think that's why Howard Hughes was hiding, because he figured he was next. That's obviously why Howard Hughes was hiding, and I think Donald Trump was approached too. What happened is in 1984, this is well documented. It was a helicopter crash. 3 of his executives were killed, and he canceled out at the last minute. And so, and I happen to know a little bit about helicopters. The reason for the crash was that the blades came off, and I've never ever heard of blades coming off a helicopter. So that's a problem right there. And so, so I think they tried to kill him, and I think Trump knew exactly what the threat was. And matter of fact, he had his own private security when he was in the White House. Anyways, in reality, they're not after me; they're after you. I'm just in the way, and really, I don't know for a fact if Trump is really trying to do it. I like to think he is. I hope he is. But at the end of the day, if we the people wake up, then it doesn't matter. One guy can't do anything about it anyways. And so we the people just need to get off our backside and start convening our militias and convening our common law courts and doing all of that stuff. And all of that stuff would go away. That's what really needs to happen. One guy, yes, if Trump is working for us, that's wonderful. I think he is. But it really doesn't matter if we the people wake up, does it? Anyways, I'm giving you your country back from the criminal psychopaths who stole it from you, and half of you don't even know it yet. And that's entirely possible. I believe it's true. There's a lot of people that have contacted me on my YouTube channel, and they have serious doubts, and that's fine. That's okay. The bottom line, though, is that it's got to come from we the people anyways. About 18 months before Trump's first indictment, I got an email that said he would be indicted. And do not worry, it's all part of the show. Just before the first indictment, Trump came out and said, I am your retribution. And if you've been in harm by the deep state, I'm going to go after him. So he was jerking their chain. He wanted him to indict him. Think about it. Just before the most recent indictment, Trump started to talk about public hangings. He is jerking their chain big time. He's trying to goad them. He wants them to do all that stuff. I hope they don't. I hope he's got real good protection, I'll tell you, because I don't want to see anything bad happen to that guy. Anyways, the deep state's in complete panic mode, and Biden does not have the 747. I can tell you that airplane that he tripped on the steps going up, that was not Biden. And I can tell you that, I don't know if it was Biden or not. That wasn't the 747, I should say. That was a 787. So I think Trump might have the White House, might have the 747. I don't know, but this is all speculation. The White House is vacant. I've heard there's YouTube videos about it. People go there and the grass is all overgrown and there's nobody there but security. And now I heard, okay, then again, this is just rumors, but some of them are from pretty good sources. Anyways, I heard that the Insurrection Act was not signed. He was given an opportunity to sign it. Sidney Powell left at night, and she was supposed to come back the next day to sign the Insurrection Act. And when she came back the next day, her White House pass had been revoked. And so what I heard happened was that overnight, Trump had talked to some generals, and they had told him that he could sign the Insurrection Act, by all means, that it was within his power, but that when Lincoln signed the Insurrection Act, that within 6 months we were in a civil war. And they had gamed out all sorts of scenarios. They believed that we would do the same thing again, and they had gamed out all sorts of scenarios, Civil War scenarios, and that the Republic does not survive. And so Trump decided not to sign it with the intention of waking the people up, and he's certainly been doing that. Which is one of the reasons I think he's working for us. You know, they hate his guts. That just says volumes for him, in my opinion. Okay, so let's keep moving here. For those of you who have been wronged and betrayed, I am your retribution. That's what he came out with. So we're going to talk a little bit about grand juries. That's power back in the hands of we the people, okay, folks? Without thorough and effective investigation, the grand jury would have been unable either to ferret out crimes deserving of prosecution or to screen out charges not warranting prosecutions. I prefer dangerous freedom over peaceful slavery. Because the grand jury is an institution separate from the courts, over whose functioning the courts do not preside, we think it clear, as a general matter at least, no such supervisory judicial authority exists. Okay, the grand jury is completely independent. That's we the people, folks. Rooted in long centuries of Anglo-American history, the grand jury mentioned in the Bill of Rights, but not in the body of the Constitution, has not been textually assigned, therefore, to any of the branches described in the first three articles. It is a constitutional fixture in its own right. I think this was Scalia that wrote this decision. It's very good. In fact, the whole theory of its function is that it belongs to no branch of institutional government, serving as a kind of buffer or referee between the government and the people. Although the grand jury normally operates, of course, in the courthouse or other judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the functioning of the grand jury has generally been confined to the constitutive one of calling the grand jurors together and administering their oaths of office. And that's the only thing that judges do. The grand jury's functional independence from the judicial branch is evidence both in the scope of its power to investigate criminal wrongdoing and in the manner in which that power is exercised. Recognizing this tradition of independence, we've said the Fifth Amendment's constitutional guarantee presupposes an investigative body acting independently of either prosecuting attorney or judge. Check out my other videos: Bankster Thieves Playlist, Roman Cult Playlist, Bankrupt Corporate So-Called Governments, Bar Members 1 through... Damn. I think I needed to update that. It's 1 through 8. Do-it-yourself, how not to volunteer for the selective service in the draft, martial laws here, do-it-yourself, no income tax, do-it-yourself, free mail, do-it-yourself, kangaroo courts. Damn, I missed that, didn't I? It's 1 to 25. Canada Border Pigs playlist, bar members and their satanic connections playlist. So you have two choices. Organize yourself into militias and juror assemblies, or continue with the same routine, but you can expect to continue to be abused, assaulted, kidnapped, sold into slavery, property stolen, and murdered. Okay, that's the choice. Choice is yours. Got to start thinking about that. The choice is yours. Are you fed up with it now, or do you need to get abused some more? There's a Texas Juror Assembly conference calls on every first and third Tuesdays at 7:30 p.m. This is the dial-in number and the access code. There's a National Assembly website. For those who don't live in Texas, roll call is every Thursday evening at 8 p.m. Central Time. 1 hour, first hour is business, second hour is general chat and education. And there's the phone number and the access code. And again, this PDF file, I'll make this a PDF file and I will link it. I'll upload it to Google Docs and link it in the show notes of this video. And what you do is don't call me for access to it. Okay, you just download it and you can have it. Okay, and then you can copy it and do whatever you want. I will not authorize access to anybody. It'll be available to anybody that has a link and you just download it and save it on your hard drive, and then you can look at it and do whatever you want. In suits of common law where the value and controversy exceed $20, the right of trial by jury shall be preserved, and no fact tried by jury shall be otherwise re-examined in any court of the United States and according to the rules of the common law. This is like really powerful. Okay? No court can review findings of fact by a jury, a common law jury. So if you convene your common law juries, you need to find lots of facts. Find the facts that are relevant to the case. And I would have a list of facts that we found. We, the jury, found the following facts to be true. And then based on that, this is our decision. So then they can never, ever review your facts, except to the rules of common law. But they never want to be common law, you know. And so, anyways, that is really powerful. That is really powerful. The founding fathers really were brilliant when they put that Constitution together. There's so many little nuggets in there that are just so powerful. Anyways, Patrick Henry said, "Give me liberty or give me death," after he witnessed a man flogged to death for refusing to take a license. It behooves every man who values liberty of conscience for himself to resist invasions of it in the case of others, or their case may, by change of circumstances, become his own. If you fail to educate people about jury nullification, karma says you'll get a jury of idiots. And so we all need to educate people about jury nullification. Jury nullification, for those of you who don't know, is the power of the jury to ignore the law. Okay? And that's a fundamental principle. And say, well, this guy shouldn't even be on trial because that law is a stupid law. We're not even going to acknowledge the law. That law is a stupid law, and we're finding him not guilty. That's the power of the jury, folks. They used to do it in colonial days all the time. The crown had to take people to England to put them on trial because no jury would convict them here. That's the power of a jury. Time to wake up. If you love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you were ever our countrymen. Samuel Adams, father of American Revolution, one of the Sons of Liberty. That's the group that did the Boston Tea Party. Quoted from the debates of 1776. When it shall be said in any country of the world, my poor are happy, neither ignorance nor distress is to be found among them. My jails are empty of prisoners, my streets of beggars. The aged are not in want, the taxes are not oppressive. The rational world is my friend, because I am friend of its happiness. When these things can be said, then may that country boast of its constitution and government. Well, I got to tell you, we have nothing to boast of here. Never forget the men who started this country were marijuana-growing, whiskey-drinking, tax-evading rebels who left their beds at night to shoot at the cops. We need to get our common law juries going, our grand juries, and our militias. And that other video, I uploaded it. It's Militias 3. And it goes through the colonial acts. There's a bunch of really interesting stuff in there about the fact that people had to be armed, and the fact that the militia wasn't subject to the county sheriff. The county sheriff could call him up to duty, call him up, but he couldn't tell him what to do. Anyways, same with the governor. The governor can call him up, but he can't tell him what to do. Anyways, but if the watchmen see the sword come and blow not the trumpet, and the people be not warned, if the sword come and take any person from among them, he is taken in his iniquity, but his blood will I require at the watchman's hands. Either you're part of the problem or you're part of the solution. You are now a watchman. Circulate this video far and wide. We need to reconstitute our militias. Watch that video about the militias, and we need to convene our common law juries and our grand juries. And we have a solution, but we're going to have to get our backside up and start doing something about it. It's either that or get used to being a slave. Which way would you like it? Thanks for watching. Have a great day.